So for those of you who may or may not be aware of the Dispute Settlement Centre of Victoria, we are a government organisation, a state government organisation, hence the Dispute Settlement Centre of Victoria. We provide free dispute resolution advice and mediation for people with a variety of matters, including neighbourhood disputes. So, as well as neighbours, which really sort of take up about 3/4 of all our inquiries throughout the year, and we get about somewhere between 20 and 25,000 calls a year. We also do help people, for example, if they're incorporated in association disputes. Sometimes we manage disputes in school community when, for example, there's outside of school disputes between families. We don't do family law matters, but we do sometimes help with, intergenerational conflict between families or people in share houses and those other households. And we even help people resolve disputes in workplaces. Again, it's often generally your community organisations who might contact us if they don't have a HR department to help them out with their disputes. So the range of our service is really about helping people who have some kind of ongoing relationship and there's conflict in that relationship which is causing stress and friction, and we can help people with methods of better communication. I should say that we're not the only player in this field. So on the right there you can see that we've got places like Family Mediation Centre, Relationships Australia, LifeWorks, those kind of organisations that work in the family dispute resolution space. So if you've got a dispute between separating partners, then we would refer you on to those services because they provide a range of things as well as mediation. They provide counselling, behaviour change management programs, those kind of things. And they can also certify agreements for family law. The other kind of services is also a very healthy private legal sector as well. So places like the Resolution Institute, but as well as the Law Institute, the courts and the Victorian Bar all provide mediation services for people who are actually involved in civil legal disputes. And finally, there's a range of other statutory services like Small Business Commissioner, which help with small business disputes, Fair Work Ombudsman, who might manage disputes around pay and conditions of employment, the Victorian Equal Opportunity Commission, Human Rights Commission, who look after discrimination issues, so they provide a conciliation service. So I've been talking a little about mediation, so before I started to get into the neighbourhood side of things, I just want to sort of talk about what our role is, because different people can help intervene in resolving a dispute. So there's the people that you can call on. Sorry about this, my button seems to have frozen up for a second. So you might, for example, get a lawyer, or you might get a support person to help you. A support person might be, a counsellor or a friend even, to help you on your side of your argument. You might call in an expert to evaluate the problem. So this often happens in building disputes where a builder and a client have an argument over the quality of work. So they get an expert who comes in, who writes a report and states what work they think needs to be done. You could take the matter to court. So, and I'll talk a bit about that, the context. With a lot of neighbourhood disputes, there might well be a legal remedy. So that's a process where you have to engage lawyers and expend a fair bit of money and wait for the court process to reach a determination. So the good thing about that is you get finality of judgment, but it might not go your way. So there's always a risk involved when you take legal action, which way the decision will make. Because sometimes both sides have a strong case, and it's a question of one person has to be right or wrong. Finally, there's mediation, which is a service where we provide, which is where you actually get someone to help you broker an agreement. So this person helps define the issues, helps both sides understand what the other person's point of view is, and looks for a win-win solution or a compromise depending on what might be achievable. So that's our preferred method of helping people resolve disputes if they can't resolve it themselves. So let's get into some of these disputes that might come across the desks of the Dispute Settlement Centre. And this is a picture from my backyard I took this morning. And it does cause me a bit of concern because, as you can see, the branches are on my side and they're actually extending over the neighbours. So tree disputes, when it comes to this, if my neighbour had some concerns about these branches, this is not something that they can go to the council. If those branches are owned by me, and this is over from one private property to another, it's something that has to be resolved between the two neighbours. We call that common law or court law. So if the branches are low like these and they're causing my neighbour a problem, they can do one of two things. They can ask me to remove them. As a courtesy, I should go back and trim these, and I do plan to do that after taking this photo. So just a trigger warning for anybody who has this kind of thing. This bougainvillea stuff grows really quickly. But my neighbour also has the right to trim these back if it's encroaching on their property. So this is called a right of abatement, which means if you can do some kind of self-help action, rather than having to go to a lawyer and serve me with a letter of demand, if they can simply trim back the branches, then it's an easier solution. Now, those branches are actually my property, even though I probably don't want them. So my neighbour can just return them back over the fence. But when people call us and tell us about this situation, we usually tell them to just apply a dose of common sense when it comes to returning the branches, because these branches, you know, if they're just thin bougainvillea branches like this, there's no problem. But if that was a, 50-kilo gum tree limb that they just hauled back over the fence, it could cause some damage. So the other thing, of course, is they have to be careful that they don't, in pruning the branch back, kill the whole tree. As I said, sometimes the challenge with these kind of matters is not the right and wrong, but it's the ease in which you can enforce a remedy. So if my neighbour asked me to trim these back and I decided not to, then they would have a difficult time forcing me because they would have to go through private legal action, which is expensive and might be disproportionate to the cost involved. So they're lucky that they have a nice neighbour like me, I hope.
David, just before you move on, we have a question.
Yeah. Right.
If you have neighbours' fruit hanging over your fence, are you allowed to pick them?
Well, are you allowed? I guess the answer is it is actually still their property. So looking at the common law, my understanding is that you should actually return it to them. But if they can't see the fruit, and if you take the fruit and eat it, how are they going to enforce that or prosecute that? So in terms of strict execution of the law, it might be a hard thing to say if they are concerned if you've eaten their fruit. And I guess that goes for found objects too. So for example, if you have a fruit tree and the fruit branches go onto the footpath and then the fruit falls onto the footpath, then you don't pick it up, then it's anybody's fruit. So I hope that answers the question. This next picture is also from my backyard in the other direction. This thing's a beautiful tree. It's a crepe myrtle, but it does grow quite high. And I've kept that prune back so that the branches don't go over the neighbour's fence. But often people contact us because even though the tree is not encroaching over the boundary, it's still causing them concern, because at autumn, this thing can dump a lot of leaves. Or actually, I think in early autumn, it produces these magnificent red flowers that can go everywhere. So the question is, should I be required to prune this back and make it smaller? And the answer is, again, it depends on if it's causing a private nuisance. And as I said, this is sort of general information, foundational. You would need to speak to a lawyer about what constitutes a private nuisance. But what I can tell you is that it is something that you would need to get a lawyer to enforce. So you would have to take legal action. You would have to sue your neighbour for creating something that materially interferes with your use and enjoyment of the land. And often it's a question then of proof and evidence and extent. So what in one person's eyes might be simply annoying or irritating, might in another person's eyes say, well, this makes my house unlivable. And there are often, you know, questions about whether if this is a tree that's, you know, produces allergies or that kind of thing, whether that makes a difference versus just, you know, the inconvenience of having to sweep up a bunch of leaves once a year. And of course, the issue before any judge or magistrate is they've got to think, well, people have a right to grow trees and have trees in their backyard, but also the other neighbour has a right to use and enjoy their property. And the question that the judge has to balance up is which rights are interfering with other people's rights. The other thing is with trees, sometimes it's not the branches that cause the problem, it's the roots. So roots growing under the fence line can create problems if they extract moisture from the soil, and where I live, you know, highly reactive clay soil, it could cause cracking in footpaths or walls. So again, if there's that kind of damage, it could be nuisance or it could be negligence or neglect. That is the basis for your claim, but the same problem arises, which is that you would need to speak to a lawyer and take legal action, and you would have to prove that it was the neighbour's actions or failure to act that actually caused the problem. And sometimes proof is very hard, because if you live in an area with reactive clay soils, who's to say it's the tree that caused it and not just recent rainfall, for example? If tree roots get into terracotta pipes, were the pipes already cracked and damaged? Did the tree roots get in there, or did the tree roots actually cause the damage? It's very hard to say because it happened under the soil. And the other factor that you need to consider too is how long has the neighbour been owning that house? So if somebody just moved in and they had a tree like this, are they responsible for the previous owner's neglect? So there's a number of factors that you would need to think about if you were going down to take private legal action. So that's why it's always worth having a chat to someone like the Dispute Settlement Centre to see if there are ways that you can resolve this amicably. The other thing to consider is that I'm not quite sure what the situation is, Moreland City Council, but when you have a significant tree like this, some councils have a significant tree register. So regardless of who's cutting it, whether you are or your neighbour is, a permit needs to be applied for from the council. So often there isn't anything, but it's worth making that inquiry first. Now, in this situation, where the tree is solely on my property, my neighbour can't come back and perform abatement, because if they came onto my property without my permission, then that would be trespass. So, and that is a criminal offence. They could be charged if they walked around to my backyard through a closed gate to try and chop this back. Often what we find is that we might have a neighbour who's agreeable to having the tree being pruned back, but they don't want to incur the expense. Or they might be happy for the tree to be pruned back, but they don't want to give access to a cherry picker or some heavy equipment to come around in their backyard. So these are things that need to be negotiated between neighbours, and it depends on the extent of the problem and their relationship as to how well they might be able to negotiate a solution. Let's see, there's a question in chat. Right. Thank you. So Heidi's put in chat the council's information. So all these points that I've got here, by the way, they're also on the Dispute Settlement Centre website. So if you Google disputes, you'll usually find the Dispute Settlement Centre Victoria. So we have information about trees and fences on our website. Oh, now this is a beauty. this is very unfortunate, and there's a problem that pre-existed my entry onto this property. But as you can see, this bougainvillea has chosen to grow its way through the railing of the fence. So if the short solution is that should be cut out, then my neighbour may well want to have that fence repaired or replaced. So in this situation, there is a Fences Act that, unlike trees, there is no Tree Act. There is a piece of legislation, Victorian legislation, that does set out the responsibilities of people for replacing a dividing fence. Now, that dividing fence is private property. It's a structure co-owned by me and my neighbour. And if my neighbour could just ask me, and I could agree that, yes, we need to fix that fence. We could get some quotes and just sort that out. But if we're not on good terms, or my neighbour wants to get some clarity around the action that's being taken under the Fences Act, they can send me a proposal in writing, which will state what action needs to be done, what fencing works need to be done. So they might say, we just need to replace or fix this section of the fence, or they might decide that this fence is too old and the whole thing really needs to be come down and a new fence built. Generally, people contribute equally to the cost of replacing a fence, unless somebody wants to build a different fence from the one that's been there, either something that's more expensive than usual, or they might say, fair point, that because you've allowed this branch here to grow like this, that you should contribute more for the damage that you actually caused. So we'll pay 50-50 for the other part of the fence that was just old, but this bit was wrecked by your bougainvillea, so you should pay for that section entirely. Now, I then have the choice. I've got 30 days to respond. I can either agree to that proposal, or I could come up with a counter proposal, or I could simply say not going ahead. If I don't respond at all, the assumption is that I've agreed to it and they can go ahead and build that fence. But if I have objected in any way, then they should not proceed, because that might have consequences further down the track if I then decide to take action, legal action. So the dilemma that we often have at the Dispute Settlement Centre is that somebody has a paling fence like this and the neighbour wants to replace it with a colorbond fence that's slightly more expensive. And the question is, should people still pay 50-50? And the answer is, it depends. You need to go back to the Fences Act and see there are a number of factors you might need to consider, such as what other fences are in the area, what's been there before, what the relative cost is. And ultimately, if you can't negotiate over that, it will be up to a magistrate to make a decision, and they'll make that on a case-by-case basis. So there's always a risk when you take legal action, you take a decision to a magistrate. They might see your point of view, or they might see your neighbour's point of view, depending on how the case has been argued and what the evidence and the factors are involved. So we often encourage people to see if you can negotiate a solution, because the difference between the cost of a wooden fence and a colour bond fence might be a few $100s, but the cost of legal action could go into the thousands. And then, of course, you've got to consider that if you reach an agreement early, you can get the fence built. But if you don't reach agreement, you've got to go all the way through the court process to get a court order, and then you can start thinking about getting your fence replaced. Now, I saw this this morning in my local neighbourhood, so I put there just to prove that not all trees are bad. And it's probably, this is a very bad dad joke, but I would consider this thing to be a friendly native. Okay. Here's another thing that I found in my household. This is my stereo system. And if I felt like a release and I felt like blasting loud music out there, it could actually cause problems for my neighbour. So the question is, can I do that? This is a common question that people have about music and noise from residential properties. So this information I've got here from the Environment Protection Authority, from their website. And there is an act, again, that the Environment Protection Act of 2017, that says it's an offence to make unreasonable noise from a residence. So the test is if a neighbour can hear it in a habitable room of their home. And habitable room does not include things like kitchens, pantries, toilets and laundry rooms, but the main room. So that means playing the music loudly at any time could be a problem if the neighbours can hear it. Now, there are also prescribed times. So there are times when, for things like musical instruments, electrical audio goods, and things like water pumps and air conditioners, where there are actually prescribed times where you shouldn't be running this equipment at all. And that's on Monday to Thursday, before 7 or after 10 p.m. Fridays, 11 p.m. Saturdays and public holidays before 9 a.m. Whoop, gone one slide forward. So the question again is, while the law is quite prescriptive, sometimes it's a question about enforcement. That's why people come to us, because during the day, you could go to council and their environment protection officers would come out. At night, you can call the police. They would come over. Now, the question is, what action do they take? They can fine people, but generally they give people a warning to start off with. And what we find when people contact us is that there's been a pattern of behaviour. So people have been playing the music loud, a complaint goes to the police, the music is turned off before the police arrive, or people see the police and immediately turn off the action, and then as soon as the police have gone, the sound goes back up again. So then it becomes not just, I guess, a regulation issue, but a question about people's lifestyles or behaviour. So we often talk to people about what are solutions that could allow me to enjoy my loud music and my neighbour to have their peace and quiet. So as you can see here, we've got some headphones in this picture. If I want it loud, then why don't I just put my headphones on, and that will then not interfere with the neighbour. It might be that I move that stereo away from that wall and put it in another place. So sometimes there are practical solutions that can help. You don't always have to have a regulation solution. Finally, sorry about this, my page. There's a question about animals. Now, I haven't popped some information in here, but there is a Domestic Nuisance and Feral Animal Act of 1994, I believe, the year. I'm not quite sure about that, but it's Victorian legislation and applies to the care of dogs. So while people are not vicariously liable, in other words, they're not vicariously liable for trees, meaning you're not 100% responsible for what a tree does, you are vicariously liable for the actions of your pets or your dogs. You do need to keep them enclosed in your yard. They cannot run out and upset and worry other people. When you take them in a public area, they have to be under the control of a lead. And the reason why I mention this, and that's why we've got this illustration here, is that sometimes people say, oh, look, I desperately need a dividing fence to keep my dog in. And they say that means that I should be allowed to make my neighbour pay for a replacement dividing fence. But in that situation, personal need is not the same as a legal need. The neighbour can still decide whether they need to replace a fence or not, depending on what damage they think is involved, whether they need a repair. So the usual negotiations that you have over a fence is the same whether there is a dog on the other side or not, because the person who owns the dog is responsible for that dog. And if there isn't an adequate fence, they still need to make sure that the dog does not leave the property or upset or worry people. So it's the dog owner's responsibility to put up a temporary fence or to restrain their animal, however that's required, if they think there's a risk of it getting out while the fence is in a state of disrepair. So the other aspect, and for both of these issues, if there is a concern about the behaviour of animals, then you can certainly go to your local council and speak to the ranger. If there's an issue of dogs getting out and worrying people, or if they're creating excess noise. So they have powers, again, to fine or even take the animal away if it's creating nuisance noise. But they need evidence, and that's often the challenge, again, why people sometimes come to the Dispute Settlement Centre, because while there's a regulation response, there's also, it creates tension between the neighbours when one person feels that the pet hasn't been properly managed, but the pet owner actually might be taking great steps and just has not had any success yet in trying to manage the issue. So sometimes the actions of the animal create strain on relationships between neighbours, and a prosecution response by the council will only go so far to fixing that up. So that's sometimes why a service like ourselves can still be helpful. So now getting to a little bit about where we fit in. And the thing about a lot of neighbourhood disputes is that they don't just suddenly happen. It's often a growing thing that somebody's doing something, and it might be that they're parking their wheelie bin too close to the boundary, or they might be playing loud stereo, and that creates a bit of discomfort. Then people try to have a discussion about it. That might be taken the wrong way, leading to misunderstandings and tension. Then there's some kind of incident or crisis whereby police are called out, or people end up shouting at each other, and that precipitates a contact to the Dispute Settlement Centre. Of course, it doesn't happen in a linear fashion like that. It often happens up and down. So the question about when can you get a third party like a Dispute Settlement Centre to intervene and help with the communication, it's often very much a question of timing. If we're very early on in the dispute, then it might not be appropriate to get someone from the government to come in and step in. Neighbours might find that actually counterproductive. So if it's very early on, we might talk with you about how you can negotiate effectively with the neighbour without our intervention. At the other end of the scale, if there's been a crisis, our involvement again might be limited because we do need the cooperation of both sides. And if we've just had an episode where people are very emotive and then we get involved, people might quickly say, no, we don't want your help. So sometimes we need to wait till things calm down a bit before we approach people and see if we can do something like mediation or a brokering of agreements. So one thing to consider is, particularly when people are in crisis mode, it's the right hemisphere or the creative side of their cerebellum that's activated. That's the side that reacts to hurt and emotions, and the one that looks at facial expressions to determine what response is required. And the left side, or the logical side, has been shut down. So we often find that when people contact us, they've said, I've tried to talk to my neighbour and they weren't very responsive. And of course, what's happened is that, wittingly or unwittingly, the way they've raised the issue has created hurt or anger in the neighbour, and then they're not going to listen to your proposal to try and fix the problem. That doesn't mean that that's the end of the matter. It means we just got to try a different approach. So I won't go into here, but often when people find that the neighbour is reacting, it might be through a number of reasons. They might feel powerless about the situation. It might be that they want to replace the fence, but they can't because of financial circumstances. They might feel that they're being unfairly criticised for letting the fence fall apart or letting their bougainvillea take over. And so that attempt at communication has failed. But that doesn't mean that you can't go back and restart. The other thing is that people often struggle with the fact that they see the situation, when they describe a situation to each other, they're looking at it from different angles or different perspectives, or putting their own interpretation on a series of events. So a common problem that we have is where one neighbour wants to replace a fence. They've looked up the process they need to follow. They find out that they need to provide a notice to fence. So they come around to the neighbour's house and they present this to the neighbour. Now, that's one perspective, is that I followed the procedure, I went over, I handed it to them, I was all very nice about it. But the other person, their perspective might be, it was dinner time, I was very busy, there's my neighbour pushing his way into the house and thrusting a legal notice at me. Now, both interpretations of that event are probably true depending on your perspective. But unless we can find a way to understand each other's point of view, then communication is going to fall down between those two neighbours. And again, that's where we can sometimes help. It's in the execution of the situation where communication breaks down, and that's where we can be effective. And so I guess this is from David Rock's 7 Habits of Highly Effective People. He points out that people judge themselves by their intention rather than their impact. They judge others by the impact regardless of their intent. So again, I refer to that situation, the common one, where somebody's intention is to do the right thing, follow the law, provide somebody with a notice, but the impact to the other person feels like they're being aggressive, they're being served with legal proceedings. And so it's often a question of how things were done and not just what was done. So these are the kinds of things that often put people aside. If a neighbour wants something, like my neighbour wants me to prune back my branches for my crepe myrtle, if I feel I'm being criticised or ordered or told what to do, that might actually have a negative impact on me, and I might actually have been willing to do something about the branch, but now that I feel like I'm being forced into the situation, I might actually push back. So what we find effective is if you have a neighbour with a problem, or you have a problem you want to speak to your neighbour, is to actually not so much tell, but ask them what needs to be done. So the difference between active and passive listening. So if my neighbour wanted me to prune back my branches, for example, they might come over at a good time, a bit of small talk, and then say, David, you know, I've been noticing, sorry about this, did you notice how much stuff falls off your crepe myrtle? And I go, oh yeah, it's terrible, it covers my backyard. And they say, well, it covers mine as well. And then rather than tell me what to do, let me reflect on that and then listen to me about what solution I might have about that. Well, what do you think we can do about that, David? And then that forces me, because I'm being now asked the one to provide some help, that gives me the space to make some options and offer some help. When people want to resolve a dispute, they need their concerns to be acknowledged. They need to feel that, okay, I'm your neighbour, we are in this problem together. I want to be respected. I want to have the freedom to come up with a solution and autonomy to make my own decision about how to sort these things out. So here are some of our tips about having difficult discussions with neighbours over these kind of issues, which is, first of all, if you want to have a calm conversation, you need to make sure that you're calm too. So prepare yourself first. Don't get steamed up and then ask the neighbour to do something. Keep your emotions in check. Think about a good time and place to talk about the situation. Plan ahead about what you want to say and ease into the discussion. Use some small talk. Talk about the impact of the situation on you. Don't focus on them. And then listen to what they have to say. Give them time to think for solutions. And if it does get heated, take a break. Say, look, okay, it's not a bad time. How about we talk about this later? Now, if you've tried all that and that hasn't worked, this is why we offer mediation. Now, at the moment, a lot of mediation, because of COVID, is being done by phone, sometimes by Zoom conference. And the main value add that a mediator has is they provide a structured process. So if mediation is conducted through us, we make sure it's completely confidential. We make sure that there's no conflict of interest, that the mediators are not known to either person. It is important that both people are prepared to give this a shot. So there's a lot of preparation usually before people come into mediation to make sure that they're going to come in at least with a sort of an open mind as to how they might come to a solution. We often find, well, generally if people come to mediation, there's been a breakdown in trust with communication. So the mediators gradually, through a series of steps, build up trust to get to an agreement. Now, the interesting fact is that when people come to mediation at the Dispute Settlement Centre, 9 out of 10 reach agreement. Because if people have made the commitment to put aside half a day or however long it takes, 3 hours, then they want the matter resolved. And so they are willing to look at different options. And we actually have a high retention rate too. When we surveyed people after mediation, 6 months after, we found that something like 85% of agreements had worked effectively as planned. Even though the agreements made at our service are not legally binding, the reason why they're effective is because the people who are involved actually came up with the ideas. So to give you an example, I had a mediation where one neighbour had pulled down a wooden fence and replaced with a colour-bond fence without going through that process I described before. His neighbour refused to pay. And you would think that was the end of it, but well, one of the neighbours moved out. And then a couple of years later, they crossed paths at a local shopping centre and there was a full-on punch-on between the two sons. So the fathers had applied for intervention orders against each other and then were recommended to go to mediation by the court. So they agreed to come to mediation. And when they were in mediation, the colour bond guy said, you know, what really upsets me is you got something for nothing. You should pay, it's unfair. And the wooden fence guy, I call him that, he said, look, money's not an object to me. This is not about money. I could have paid for half a fence, but you don't deserve any money. It shouldn't go into your pocket because you didn't follow the process. Now, when we were reflecting on how the situation got to this point, I did ask them as a mediator, I said, well, does it matter where the money goes? Me thinking, well, ultimately it's the fencing contractor who benefits out of this. And Mr. Colorbond said, no, I just want to see him put his hand in his pocket. If he paid the money to a charity rather than to me, I don't care. And Mr. Woodenfence said, well, you know, I'm happy to pay money to a charity. I'm a generous guy. So they ultimately came up with a solution that the half share of the fence, which is about $1,000, went to a charity. The reason why I bring that up is because this was about them coming to their own solution. They both had pride at stake. They needed to save face. They needed to come up with a solution where both their needs would be met. And they did just that. They wrote a check to a charity. Mr. Woodenfence wrote a check to the charity there and then, and they both posted it. And then they were prepared to remove their orders against each other because as far as they were concerned, the whole vendetta between the two families had been resolved. It also goes to show that when you're in mediation, you don't necessarily get the response you were expecting, but the main point is that the people who are involved find a satisfactory solution, and it might not be the one that they would ever get in an adversarial or court-based process. Very quickly, wanted to say there's sort of three aspects to a mediation. Just like when you get in a car, you check the mirrors first, then you check your instruments before you pull out. When you go to mediation, we have to often talk about the past, and often the things that have happened in the past, they're done. We can't change them. If wrongs have been done, we can't change that. But people can then reflect on that and think, okay, well, what is a better way to move forward? And that's where a mediator is very helpful in focusing people then to start thinking about the future and how to find a solution. Obviously, before we organise any mediation, we have a general overriding responsibility to make sure that it does more good than harm. So it's important that we identify risk factors. Is it suitable? Is there no risk of violence? Is there something that can be negotiated over? And have people also done their homework? So if we've got a dispute about a fence, have people got quotes? Have they had a look at the processes that they're meant to follow before we come into mediation so that we're both negotiating in the same space? So we always say to people when they contact us and we're trying to get them to involve in mediation, what is, why should you come to mediation? Well, one of the best things, if you go to a court-based process, there's got to be a winner and a loser. But in mediation, you can have two winners and you can actually improve the relationship. It's also cheaper and simpler than going to court. It still takes maybe 2 or 3 weeks to organise a mediation, depending on how quickly and how well organised the two neighbours are. So you could call us today if you've got a dispute. And if it sounds like your attempts at communication have failed and it sounds like mediation is helpful, we can open a file on the spot. And then we would make contact with your neighbour, usually email with a letter, and we give them a certain amount of time to respond. So that's usually 2 letters over a period of 3 weeks. If they don't respond, we let you know so that you can then take the next step, whether that's legal or whatever. But if they respond, it's only 2 or 3 weeks to getting a mediation organised, just depending on, when people are mutually available and whether they have work and childcare commitments and that kind of thing. And as I said before, 85% reach agreement. And also we survey people, 85%, not the same 85%, report a high level of satisfaction to our surveys. Because often people feel like, well, if I went to mediation, then at least, I've tried everything, I've heard them out. So this information I've got again from our website. To find out more if you've got a problem, the best thing is just to call us. There's our number there, 1300 372 888, or you can send us an email through our Contact Us page on the Dispute Settlement Centre. We do have frequently asked questions about fences, and I will take your questions in a minute when I finish this. And you can even get the notice of defence form from our website as well, the pro forma. There are other services. The Law Handbook of Victoria has a great chapter on neighbourhood disputes, as well as I think Legal Aid have everyday law. And then if you need to speak to a lawyer, there's a number of ways you can go about that. Check to see if there's a community legal centre in your area. I think there is in Moreland. Not all legal centres give advice on neighbourhood matters. So you might need to hire a private lawyer, and the Law Institute's a good place to get, 3. They'll give you a list of 3 and you get half an hour with each of those lawyers before deciding who you might want to use. And I'll finish up the main part of this presentation with our contact details. So there's our website and there's our thank you. I just put in the Northern community. Now, I've got a problem here. So I'm just looking at the chat. Exercise groups, loud music, as well as So it sounds like this first person's with the exercise group, creating noise and nuisance. So with Greg, with that situation, certainly it sounds like you've tried the regulation response to look at this problem, and certainly that is the case. If somebody's running a business in a residential area, then council does have power under the planning processes to fine them. But sometimes I guess it sounds like the council has investigated this and come to the conclusion that it's not a business or one that's inappropriate for a residential area. The fact that The music is loud, as I said, seems to be something that might be covered by the Environmental Protection Act. But again, the council is the best arbiter for that. They are the ones who would go out and do the sound measurements if it was happening. So obviously the question would be, if you're getting the runaround from the council, would be to say, what attempts have you made to speak to the neighbour about this? Because this is something that, again, depending on what approach you've already taken, the first thing would be, you know, to speak to them and say, look, are you aware? I know you're running your exercise classes. It's great that you've got a source of income, but it does have an impact on us. Is there any way that we could, you know, you could reduce the sound impact? So it might be that they can put some insulation or keep the sound just down a few decibels. There are a number of solutions that they could do if you call upon their cooperation. But a lot of this, I guess, is about, you know, bargaining power. You've already looked at the regulation responses, so there's not a lot that you can do if you've already spoken to the council to enforce this. So it really is about trying to work for a cooperative response. And certainly it is the kind of thing where you could go to the Dispute Settlement Centre and we could write a letter if we haven't done so already. If you've already tried to speak to her and that hasn't worked, sometimes getting a letter from the Dispute Settlement Centre does give people a second attack. They go, oh, okay, they're obviously wanting to take this to the next step, and they might take your request a bit more seriously. The next question is about damaging to the nature strip and the grass. Yeah. So again, the question there about people damaging the nature strip, again, that is something that local laws can enforce, but again, often it's about evidence and whether they're going to take a response if it's only like a one-time issue, it's just damage to grass. And if there's no way to prove that, apart from your witness statement, there's no way to prove that the damage is actually being done by her. I guess the question is to what you want out of this, because it sounds like you've got frustration that you're a friendly neighbour, you help them, but this is the response. So again, if you raise your concern with them, you've got to think, was it that I actually want from them? I don't want just to acknowledge that, yeah, I did that and sorry, it won't happen again. Did you actually want them to come over and fix it up? How realistic is those expectations in the circumstances? And, you know, when we come to mediation, again, something it could be something that you might think about approaching for mediation. Usually if it's a one-off incident, mediation's probably not going to help a lot. If it was a recurring thing where the damage was always being done and that was really inconveniencing you, then it might be worth approaching through mediation. So it's a question of whether you want to let it go, whether you think that this is something that is a repeat occurrence, you need to change things or not, as to whether it's worth pursuing further through something like mediation. Right, so we've got a few. So just some additional comments there from Greg that Right. So it doesn't look like it's a regular thing happening. Yeah. Sometimes, it might be worth, if it sounds like what you want is to have something to fix the driveway, it's a question of maybe even saying to them, would you prefer me to fix this, or would you rather, and send you the bill, or would you rather fix it? Sometimes giving people the impression of a choice can help get a solution. But again, it's a hard thing for you to force her to do if she decides not to help at all. It's just frustrating, unfortunately. Okay. So we're right on 1:30 now. I'll just check the Q&A too, in case somebody has left me any messages there. There's no questions there. Everything's been in the discussion. Okay, Heidi, I might now call an end to this unless there's anything else that you wanted to ask me as a host.
No, thank you very much, David and Kerry-Ann. That was fantastic. You've got some really good information there. And hopefully people saw the links that I put in chat, and you can follow those. Unfortunately, my work laptop has blocked the Moreland City Council website, so I couldn't add anything there. But if you go to moreland.vic.gov.au, there'll be a search part there you can look under for any sort of animal complaints or anything you're looking for council. Yep. But once again, thanks very much, David and Kerry-Ann. That was fantastic.
And I should just add, by the way, that when you contact us, you don't have to give us your full name and details. If you're just after information, or you just want to talk to somebody about some strategies that are involved, obviously we need a name for the purpose of conversation, and we like to have a bit of profile information, like where your suburb is, so that we can keep statistics. But you don't need to provide full name and details if you're just contacting us for information and support. We only need your details if we're going to be writing to the neighbour, making contact with them, because they need to know who's initiated this. Okay. Well, thank you, everybody. Hope it's been of help, and please take note of those contact details if you need to contact the Dispute Settlement Centre.